Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. Welcome to the Tenant Law Podcast. I am Michelle Itkowitz. On December 16th, 2024, the New York City Council managed to pass a new law, Local Law 119 of 2024, which prohibits real estate brokers from passing their fees onto residential tenants where the broker is exclusively representing the landlord's interests. This would include brokers who publish listings with the landlord's permission. Landlords and their agents are also required to disclose the fees that the tenant must pay in their listings and rental agreements. First, as always, let's set the stage with some context. A tenant renting an apartment in New York City often is required to pay a broker fee for the landlord's broker, even if the tenant never hired the broker or even if the broker does almost nothing for the tenant. This has long been a controversial practice in New York City, especially as technology has made it so much easier for landlords to list apartments online with virtual tours and tons of information, and for tenants to find apartments online and to communicate directly with landlords on such platforms. So on December 16th, 2024, the New York City Council managed to pass a new law, Local Law 119 of 2024, which is also known as the Fairness in Apartment Rental Expenses Act. The law operates by adding to the New York City Administrative Code, Chapter 4, Title 20, a whole new subchapter, Subchapter 15. I will put a link to the actual full text of the law in the show notes. We're going to go over the law in detail. The new law tells us that a landlord's agent shall not impose any fee on or collect any fee from a tenant related to the rental of residential real property. And any agent who publishes a listing for a rental of residential real property with the permission or authorization of the landlord for such property also shall not impose any fee on or collect any fee from a tenant related to the rental of such property. You, as a tenant, can hire a broker if you want one to help you find an apartment. Maybe you're coming from out of town and don't know New York well. Maybe your company hires a tenant broker for you to make the process of finding an apartment easier. You can hire a broker if you want a broker. But what can't happen is you can't be forced to pay a broker that the landlord has hired exclusively. And they don't want to be quibbling about what does it mean that the landlord has a broker. So that's why they put the second part about any agent who publishes a listing for a rental of a residential real property with the permission or authorization of the landlord. That's the same as it being the landlord's broker. Also, elsewhere in the statute, they have a section that says that it's a rebuttable presumption that an agent who publishes a listing for a rental of residential real property does so with the permission or authorization of the landlord. So if a broker publishes a listing, it is presumed that it's doing so with the permission and authorization of the landlord, which is the same as that being the landlord's broker. Then the law goes on to tell us that no person shall condition the rental of residential real property on a tenant engaging any agent, including but not limited to a dual agent. The landlord can't say to you, well, I'd love to rent you this property, but I can only do it if you hire my broker or if we hire a broker together. That's what a dual agent is, an agent who's simultaneously working for the landlord and for the tenant. And then the law goes on to say that no person shall post a listing for the rental of residential property that represents that fees must be paid in a manner that would violate this law. So it's not only that you can't charge the fee, you can't even advertise about the fee. Then the law has a whole other section called total fee disclosure that could really be more comprehensive than just talking about broker fees. This section of the law tells us that every listing related to the rental of residential real property shall disclose in such listing in a clear and conspicuous manner any fee to be paid by the prospective tenant for the rental of such property. Okay, so let's talk about penalties. The law tells us that any person who violates the no passing along the landlord's broker fee part of the law shall be subject to a civil penalty. That means a fee that will end up going to the city, a civil penalty of not more than $1,000 for the first violation and not more than $2,000 for each subsequent violation occurring within a 2-year period. And then any person who violates the disclosure of fees requirement shall be subject to a civil penalty of not more than $500 for the first violation and not more than $1,000 for each subsequent violation occurring within a 2-year period. Then the law goes on to set up a private cause of action. So it's not only that violating the law can result in a landlord or an agent having to pay a fine to the city, it's also that you can sue the landlord to get the money back if they violated this law and you had to pay this fee that you weren't supposed to pay. There are also some other penalties built in there. Finally, this law will be administered by the New York City Department of Consumer and Worker Protection. I just checked their website and nothing's up on there yet, but that's probably because the law starts in 180 days, so sometime in the middle of June 2025. And that sets the stage for today's comments. This law is new and changes things a lot. Whenever that's the case, I see various ways that the law can get off to a bumpy start. Let me start by saying that most landlords will follow the law. Most landlords and most real estate agents will follow the law, but some will not. So let's talk about that. First, some landlords and their agents will simply not have heard about the law. It is amazing to me how many multifamily landlords are still surprised by the details of something like the security deposit laws that are now like 5 years old. They just have no clue. Ignorance, of course, is no excuse for not obeying the law, but the point is there will be landlords in June 2025 that are simply clueless and they will expect their new tenants to pay their brokers like they always did, so there will be somewhat of a learning curve. Second, some landlords and their agents will know about the law but will simply ignore it. There are people like this in every industry who will just not obey the law until they get dragged kicking and screaming, until they get prosecuted and have to pay fines for it. Such people, I think, sometimes do the math and realize that they'll make enough money from all the people who do not call them out on it, and by the time they get caught, it will be worth the fine. I don't know what they think, but you always get some people who just keep doing what they've been doing and they just ignore the law. Third, some landlords and their agents will try to find a loophole. And these are really the worst. They'll create a fee, but it won't be a broker fee. It'll be a help in finding an apartment fee. In other words, they'll just find some other way to demand the extra money from tenants. And these are the people who will eventually be prosecuted by the New York City Department of Consumer and Worker Protection. So you always see some of that. Again, most landlords and most agents will follow the law, but these are the places where I see that when something changes a lot, this is the inertia and the resistance that you get. The fourth bump in the road, if it happens, would be the only legitimate bump. So, the Real Estate Board of New York, that's a landlord trade group, is looking to strike down the new law with a lawsuit that it filed in federal district court. They're represented by a big firm, and the Real Estate Board of New York is arguing that the mandate blocking brokers from passing along their fees to tenants will effectively eliminate brokers' rights to advertise open properties, and thus it violates their free speech. And they also say that the law violates the contracts clause of the US Constitution because it interferes with the contract between the landlord and its broker. And they say that the law will conflict with the state's comprehensive regime of laws and regulations governing real estate brokers. I am not a constitutional lawyer, but the federal constitutional claims just strike me as ridiculous. I mean, free speech, really? I never understand why big real estate hires big law to file big lawsuits in big courts over laws like this. They just so seldom work. And the claim about the city interfering with the state law on brokerage, there might be something to that, but I doubt it. We will find out eventually if this litigation is going anywhere. It will probably take years. All of this brings up some important tenant takeaways, but first let's get the housekeeping out of the way. This is not legal advice, and I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it is terrible because I am asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. Please subscribe and give us the highest rating, and it is time for the tenant takeaway. Tenant takeaway time. If the law is not altered or struck down and it goes into effect in mid-June 25, what should you do if you find a landlord or an agent asking you to pay the landlord's broker? You could seek to educate the landlord by pointing them to the statute, which I'm pointing you to, and you can also show them any number of news articles. There are a ton of news articles about this. Remember, the landlord is not allowed to refuse to rent to you because you refuse to pay a fee. Most landlords will likely back down when the law is pointed out to them. If they do not back down, then you can report the landlord to the New York City Department of Consumer and Worker Protection. As of this recording, there's nothing up on their site about this, but again, it doesn't go into effect for another 6 months. If you do end up paying a fee after the law goes into effect, you can still report the landlord to the New York City Department of Consumer and Worker Protection, and you can sue the landlord in small claims court to get the fee back. I never recommend to tenants withholding rent. Also, remember, it's illegal for the landlord to refuse to renew your lease because you asserted your legal rights in any way within the last year. And soon we will do an episode on retaliatory eviction. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.